Welcome. Professor Domondon is back, and this time I shall discuss for you part 2. Part 2 asks you the question, why do we have bar flunkers? What makes a bar flunker? The Supreme Court normally requests the bar examiners, when the bar exams are released, to make a report on what they believe are the reasons why some individuals fail the bar examinations. This is a synthesis of said observations plus my own personal observations when I was a member of the Board of Examiners for the bar in 2011, and also the instances when I had observations personally on other bar examinations. First, you have the inability to recall. Second, students have nothing to communicate. By the way, we shall discuss this in detail later on. Lack of communication skills, horrendous English, as defective logic, as eligible handwriting. Then another factor would be inadequate preparation, no discipline and dedication, carelessness, lack of broad legal foundation, inability to focus, failure to run the marathon. So let's talk about them in detail one by one. First is inability to recall. Of course, if the student could not remember what he has studied during his 4 years, and also during the bar reviews he had not taken, and he could not remember them, then there's nothing to write in the bar notebook, therefore the student fails. We usually say that the theme song of students who take the bar is Maalala Mo Kaya. Do you remember? To be repeat. If you could not remember, if you could not recall, then there's nothing to write. Another is nothing to communicate. So, he does not know anything, so he could not write anything. Then you have lack of communication skills. The bar examination is a written test in English, and therefore, here, if the student has horrendous written English, in short, he could not express himself very well in the English language, then it stands the chance of not being able to pass the bar exams. So also, defective logic. He does not know how to reason out. Now, it might happen that the student has good English, he has impeccable logic, he remembers all that he has studied during the review in undergraduate years. But if he has illegible handwriting, then the examiner could not decipher what he's talking about, and he is liable to fail in the bar exams. Inadequate preparation is also one of the factors why some students fail in the bar exam. You do not prepare for the bar examinations by going to the bar. There's a different kind of bar. So again, you must have adequate preparation. You must have a well out plan and be able, therefore, to overcome any obstacles you meet during your bar review. Then, no discipline and dedication. Once you've come up with your plan, you must observe your plan no matter what. Then, carelessness. The student looks at the problem in the bar and he believes the factual setting is familiar. And consequently, he immediately recalls to mind what he believes is the particular case involved. But if he's careless and does not discover sometimes that the examiner has already removed some factual elements or added some factual elements so that the doctor ruling is already different, then the carelessness will cost him a lot, especially when he takes the bar. He'll have to pay the supreme penalty. In such instances, the supreme penalty is failure in the bar exams. Then there is one that's very controversial. Some authorities believe that students fail in the bar because of lack of broad legal foundation. But to my mind, this is not that important. Why not that important? Because not all areas of the law are subject of bar examination questions. There is a pattern of bar questions because your examiner wants to test what he thinks is important. The bar examinations have been given from 1913 up to 2019. And consequently, even if the examiners have not talked with each other, they must have a notion on what is important. In short, they must have a notion on what is required for an entry-level lawyer to practice his profession. It's a matter of identifying the patterns and then mastering the patterns. As a matter of fact, I even counsel some of my students not to read the books and reviewers from cover to cover because they might only remember the cover. The human mind is like a computer. The more data you put into your mind, the more it's difficult for you to retrieve. So take note of that. I identify patterns, and once you've identified patterns, then that's what you're going to focus on your discussion. You also have inability to focus. A person, for example, who has numerous problems when he takes the bar will not be able to focus. So, as for example, is it able to take a leave of absence when he takes the bar exams? Then his mind again is divided between his work, between his family, and also between the bar examinations. So his chances of failing in the bar is very high. Then there's failure to run the marathon. As explained in the first module, it is important you must practice. Well, let me tell you a story here. If you want to run the marathon, what do? You read all the good books about the marathon. Then you try to get a good coach to run the marathon. But despite all the good books, despite the good coach, if you do not run the marathon, you do not practice, then again, you will not be successful in finishing the marathon. The same thing is also true with the bar exams. You must have all the good materials. You have your books, you have your online materials, you have good coaches, your professors, and bar reviewers. But if you don't practice answering bar questions, you will not be able to pass the bar exams. Now, the other modules shall address the foregoing deficiencies, specifically the first module that we shall upload or we have uploaded already, because I'm not sure whether we uploaded the first module. The first module teaches you what to read, when to read, how to summarize, how to outline, and other similar character that will help you during your review. These modules help you solve the following issues so you will top the bar. So what are these issues now? Upon due analysis, to my mind, one of the reasons why there are bar flunkers is that they were not able to finish the exams, they failed to understand the questions, and consequently, if they fail to understand the questions, then their answers are going to be wrong. Also, answers could not be understood. Why? Because they lack analytical skills. In short, they don't know how to reason out. So, the examiner is your friend. Before you have a person as your friend, you must know your friend. You must know the characteristics. You must know the habits of your friend. By the same token, you should know what the examiner does. How does he evaluate your answer? So, if you make it easy for the examiner, knowing what he does, and you make it easy for him to correct your notebook, then love is repaid with love, amor con amor sa paga, and he shall give you a good grade. It is important for you to know how the examiner evaluates your answer, so you could craft your answer in accordance with the manner by which the answers are corrected. The basic elements of problem solving that the examiners shall particularly look for are your proper understanding and appreciation of the facts, particularly of the components or details that can be material in solving the given problem. You should also look at your appreciation of the applicable facts that may come into play, recognition of the issues posed, and the resolution of the issue through the analysis and application of the law to the given facts. I shall explain this later on when we talk about set theory, specifically the interweaving. The examiner's presentation articulation of the answers should also be given weight. How you approach your answers, how you weave, how you explain would also be given weight. Let me ask you these questions. Does the examiner work 30 days a month? Does he work 8 hours a day? Does he carefully evaluate his notebook? Does he maintain his span of attention such that his concentration in collecting the papers are the same from the first notebook down to the 300th notebook, or even more? The dog barks, the baby cries, does he lose his span of attention? The reasons why we're asking this is for you to be able to devise a methodology by which you could overcome all these problems. The answers are all no. Therefore, you should craft your answer to meet the following characteristics. If the subject weight is 1 to 5%, generally your answer should be 3 at the most 5 sentences. Where do you find the subject weight? You find the subject weight immediately after the question. The percentage points are there. Upon the other hand, if the subject weight is more than 5 sentences, well, your examiner wants to test facility of written expression, therefore your answer should be expanded. It should be more than 5 sentences. So you must write your examination answers fast. But the problem is, the faster you write, the more eligible your writing becomes. So let's look at the morning subjects to find out what is time allocated for answering each point of the problem. The morning subjects are generally those with the highest weight. You have political law, you have civil law, mercantile law, and remedial law. You're given 4 hours to answer from 8 o'clock to 12 noon. And therefore, if you multiply that by 60 minutes, you have 240 minutes. What does 240 minutes mean? 240 minutes mean that you're given 240 minutes in order to get 100. And therefore, you have 2.4 minutes per point. So if it's a 2-pointer, then 2.4 minutes times 2, that would be the time allocated for you. The afternoon subjects will be the same. And the afternoon subjects are those with lesser weight, such as, for example, labor, taxation, criminal law, and legal ethics. But funny, in the morning subjects that have a higher weight, you're given 4 hours, but in the afternoon subject with lesser weight, you're also given 4 hours. In classroom examinations, usually, whenever a student goes out ahead, your classmate goes ahead, everybody is agitated and also wants to go out. They hurry finishing their exams. But in the bar, whenever you see somebody going out ahead of you in the bar examination room, you ask yourself the question, is she a genius or is she an idiot? Why? You should not, you could not compete with a genius. But why should you compete with an idiot? So in short, the moral lesson here is that you're given 4 hours to finish your exam. Utilize all the 4 hours because it might not even be enough. What about answering bar questions? There are two aspects of answering bar questions. The first would be the physical aspects, and the second would be the intrinsic aspects. The physical aspects are like the gift wrapping of a gift. If the gift is sloppily gift wrapped, the gift wrapping is not good. It's possible that the recipient might not even open the gift at all. The same thing is true also with the bar exams answers. If your answer is sloppily written, it's not good, it's bad to the eyes, your illegible handwriting shows, then it's possible that your examiner might not even read your answer. On the other hand, if the gift wrapping is beautiful, then the examiner, the recipient, will be convinced to read your answer. And this is where the intrinsic aspect comes into play. The intrinsic aspect is the contents of your answer. If the gift was beautifully wrapped, but upon opening, the contents are rotten, of course, your recipient will get angry at you. But at the same token, if your physical aspect is very beautiful, but the contents are rotten, then also your examiner will make you pay the supreme penalty. He shall fail you in the bar exams. So, let's now have a look at the physical aspects. This is a page of my bar notebook. Look at it carefully and let us see how you could profit from looking at my bar notebook. First, I would like to have a look at the margins. When you look at the margins, you have the margin on the left side, you have the margin on the right side. Notice that the margin on the left side seems to be a straight line. You must maintain a good margin on the left side, which is usually 1 inch wide. Do not write a line to guide you have a good margin on the left side. Also, do not fold your paper. Upon the other hand, when you look at the right side margin is supposed to be 1/2 inch wide only. It's difficult to maintain a straight margin on the right-hand side. Now, having said that, why is it that the left hand should be 1 inch, the right hand should be 1/2 inch only? It's because of the fact that if you have wider margins on either side, then the space you're going to write is going to be narrower and therefore is not good to the eye of the examiner. The second thing I would like to have a look at would be the numbering system. Look at the questionnaire. You must use the same numbering system of the questionnaire in your answers. For example, if your questionnaire is numbered using the Roman system, then by all means, use the Roman system in your answers. On the other hand, if the questionnaire is in the Arabic system, then of course, you must number your answer using the Arabic system. Now, where are you going to start writing? You look at the notebook again. I made a mistake. For aesthetics, I suggest that you write your answer on the first line, top of the first line, not what I did, top on the second line. Now, if, for example, one page is not enough, you do not repeat your numbering again. You continue writing, but this time, it's going to be on top of the second line, not on top of the first line. So that's how I suggest you're going to do. What about intention? Whenever you start a paragraph, you must always indent. Even if the paragraph is only one sentence, you must always indent. What about spacing? Look at the spacing here. After the number, there is a space blank. In between paragraphs, there is also one space blank. When you start a new page, I mentioned to you that supposing that you could not complete your answer in one page, then you start writing on top of the second line on the next page. You do not renumber again. As a word of warning, look at this page of the notebook. There is a last line here. You do not write below the last line. How do you correct mistakes? Look at my answer. I made a mistake when I first wrote because I did not reflect properly. So I wrote, no more. It's a good thing I realized that before I've gone further. So if you're going to correct a mistake, do not cross out by X the whole answer. Instead, you're going to draw one line across the mistake, just one line, and then write either on top of your answer or after the line that you have crossed out. You have seen the physical aspects, and I suggest that during your practice exercises, you must use that as a guide and continue practicing until you're able to perfect the physical aspects. Now, what about the intrinsic aspects? How are you going to approach the intrinsic aspects? You approach the intrinsic aspect by looking at the different bar questions, because the different bar questions have different ways of attacking them. There are also different ways of approaching the answer. So I classify bar questions into two: objective and the essay type. For the essay type, you have theoretical discussion and fact-centered. But you're going to comment, is it not so that the bar exams is always an essay examination? True, you're correct there. But then I make a distinction between the purely objective question, such as, for example, the definitions, enumerations, and distinctions, compared where you have an extended explanation, such as, for example, a theoretical discussion problem or a fact-centered question, because the analysis would be different. So, what are the kinds of objective questions? You have definitions, you have enumerations, you have distinctions. Let's look at the manner by which questions have been asked in the past relative to the objective type. So, you have definitions from 2015 to 2019. Let us find out how the questions have been crafted. In 2015, you have the question asked, what are the minimis benefits and how are they taxed? In 2016, in political law, you have this type of definitional question. Explain the completeness test and the sufficient standard test. And then the criminal law in 2017, define will conspiracy and chain conspiracy. In 2018, you have this. What are the doctrines of separate juridical personality and limited liability? And finally, in 2019, you have to guys ask, what is a use of fraud? So you notice, and I believe that any examination after 2019 would contain definition type of questions. Then you have questions asking for an enumeration. Let's look at the manner by which questions have been crafted asking for an enumeration. What are the factors that establish the existence of attorney-client privilege 2015? So therefore, you must now enumerate the factors to establish the existence of attorney-client privilege. What are the requisites of a valid quitclaim? Labor law, you must enumerate then the requisites. Mercantile 2017. What are the three restrictions imposed by law on those three transactions? Then number 4, 2018. Be careful, this is in fact an enumeration type. If there are no qualified heirs, can the government initiate estate proceedings over the assets of the deceased? To whom in particular shall the estate of the deceased go and for whose benefit? You must write out here the hierarchy of those who are going to inherit. And then finally, in 2019, you have the question asked. Under the 1987 Constitution, what are the rights of a person during custodial investigation? For distinctions, you all have for your pattern because there were no distinctions asked in 2018. So 2015 in civil law, distinguish civil and natural obligations. Labor law 2016, differentiate between learnership from apprenticeship with respect to the period of training, type of work, salary, and qualifications. Taxation, distinguish compromise from abatement. 2018 none. 2019, distinguish compulsory from voluntary in division of judges. So that's the end of part 2. Why do we have bar flunkers? Let's just take a break, enjoy your coffee and your chocolate. After the break, we shall discuss part 3. Enjoy your break, and let's open later on and have a look at part 3, analytical techniques for objective type of questions.